Breaking news out of California. The handgun roster for the state of California has been declared unconstitutional by Judge Cormac Carney. A major win for the Second Amendment, yes indeed, and I'm very excited. However, I finally took a look at this decision, and we need to talk about it because it can be improved on in a much more favorable way to the Second Amendment than was crafted by this judge. Although I'm very happy with the outcome, he got to the right answer. We need to talk about this going forward right now. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the four boxes of American liberty. Okay, folks, first of all, you probably have already heard about this because I'm a day late because of the Second Circuit Court of Appeals and some Fox News obligations I had to satisfy, but I've got those in the rearview mirror, and now I've had a chance to take a look at this case of Boland versus Bonta out of the United States District Court for the Southern District of California. Obviously, if you don't know, this is a major win for the Second Amendment. Congratulations for the lawyers out there that handled this. The ruling says that the California handgun roster is unconstitutional because of the way it's constituted and various other things. A very well thought out opinion, but we're going to get to that in just 1 second. The judge there was Judge Cormac Carney, so a big win for the Second Amendment. Congratulations to all involved. However, the reality is that, believe it or not, although the judge got to clearly the right answer, it turns out that he applied, arguably, in my view, it's pretty clear, the wrong methodology. And I understand why this may have occurred because what I'm about to say is a little extra geeky, and I apologize, this video may have to be a little extra geeky in some parts to understand where I think the court did not get it wrong, but I think that the judge did extra work that he did not need to do to get to the same outcome. And this is something that perhaps should be considered by people involved in that case up on appeal and beyond. To start with, those of you who don't know, California has something called a handgun roster. Now, I don't spend a lot of time studying this because I don't do a lot of California because you got some really good people out there covering California gun news, so I kind of defer to them on a lot of the stuff, so I'm not totally involved and I don't study this. But I did get a chance to take a look at this decision involving the California handgun roster. Now, the way it works is there's a certain number of guns that are on this roster, but now in order to add new guns onto the roster, which allows Californians to purchase, certain things have to be satisfied. For new guns to be added to the roster, meaning modern guns that are made and created and produced in, let's say, 2021, 2022, 2023, and beyond, they have to have three things. The three things they need to have, among other things, is they have to have a loaded chamber indicator, which means that there has to be some indication when the chamber of the handgun is loaded. Number two, they have to have a magazine disconnect, which means that once a magazine is out of the firearm, it can no longer shoot even a single bullet. And the third thing is, and this is by far and away the most onerous, impossible thing to satisfy, some form of microstamping that says that when that handgun fires, the bullet cartridge left behind will have a microstamped make and model of the particular handgun that was used to fire the round, which is kind of stupid because I don't know if I was a criminal and I had a gun that had all that information. Frankly, I would probably swap out the firing pin. Nevertheless, that's not the point of today's discussion. The reality is this. Because of these restrictions that have been posed on guns that can be sold by retailers and manufacturers, there is a very small secondary market we're not going to get into for the purpose of this video, but the bottom line is for ordinary gun owners in California that want to buy ordinary modern firearms that have been made by major manufacturers, they, as a practical matter, cannot buy those new handguns in California because they're not on the roster, and guns won't be added to the new roster because they can't meet those three criteria, including the microstamping requirement, which is for all intents and purposes not feasible. Okay, now, let me tell you what the judge did here, and then I'm going to tell you what the judge could have done better and going forward, the proper way to analyze this case. What the judge did was he went out and applied the Bruin methodology of you look at the plain text of the Second Amendment. If it's been implicated, you then ask the government to come forth with historical analogs to justify the regulation that they are trying to do. And it's the government's burden to show that whatever law they have in modern day America is consistent with the long-standing tradition of firearms regulations. And that word regulations, which is part of the holding in Bruin, is very important because regulations mean legally enforceable laws and not just good concepts somewhere. They have to come forth, the government has to come forth and has the burden to show actual laws at the time of our founding that are analogs or very similar to modern day gun control laws that they're trying to uphold. If the government government cannot show it, they lose, and that modern-day gun control law is struck down. So that's what the Judge Carney did here. He basically says that obviously the plain text of the Second Amendment is implicated for various reasons, because obviously the possession of handguns touches fingers with the right to keep and bear arms, and therefore the plain text is implicated. And because the plain text is implicated, the burden shifts to the government to come forth with historical analogs to justify the regulation, and that is what the government tried to do. And again, all of this is unnecessary. I'm going to get to that in 1 second, but for now I just want to tell you what happened, then I'm going to tell you how it can be improved on. Then what happened is what actually happened was the government came forth with 2 types of laws, something called proofing laws. They tried to say there was some form of inspections. We're going to have to look into that a little bit more. I'm wondering if those laws are applicable, bottom line, because I think they may be militia-related laws, but we'll get to that down the road in a future video. But bottom line is Judge Carney did not view those as analogs to restrictions on, basically forcing certain safety restrictions on Americans that want to buy these guns in California. So he rejected those analogs as persuasive. The other thing he looked at, something we've talked a lot about on this channel, the anti-gunners always like to bring up these fire safety regulations in places like Boston. As you know, the anti-gunners always bring up these gun storage rules. And they're not gun storage rules. What they are is, at the time of our founding, there were certain rules about how you stored large quantities of black powder. Black powder. The reason why this is very important at the time of our founding is because all of the cities and towns in America were made mostly out of wood. Because they were made mostly out of wood, there was concern that if you have highly flammable storage units or highly flammable black powder being stored in homes, if heaven forbid one of those things caught fire, the entire city of Boston or the entire city of New York would burn down. So they forced large quantities of black powder to be stored outside of the city. But this has nothing to do with gun control or limiting arms. This was everything to do with fire safety. And Judge Carney did an excellent job of making that observation, which is clearly the case, because burning down entire cities due to a fire was a real thing. In fact, the city of London was entirely burned down before the American Revolution because of a fire. So fire regulations were very much on the mind of the Founding Fathers, but again, it had nothing to do with gun control in the modern sense at all. It was all about preventing and stopping the spread of fire. Okay, so after engaging in the analysis of plain text and then looking at historical analogs, Judge Carney concluded that effectively these bans on these new firearms in the handgun roster out in California was unconstitutional under the Second Amendment, and this is the right decision. However, this decision was not properly written. As I read it, I think it's clear it was not inconsistent. I want to be a little geeky here, and I want to be very precise. I'm not criticizing anyone about what happened out in California, but I want to be very precise here. The way this decision was written was well done and accurate. However, it was not necessary to do what the court did, to strike down the California handgun roster as unconstitutional under the Second Amendment. Why do I say this? Step back and think about what the handgun roster is. The handgun roster is effectively a handgun ban. Did you hear what I just said? The handgun roster in California is effectively a handgun ban. Thus is an arms ban. Here's a statement made by Judge Carney in his decision, quote, the UHA, the California statute's, quote, prohibition on sales of unsafe guns, quote, unsafe guns. California's, quote, prohibition on sales of unsafe handguns is subject to exceptions. But you see the key language here? It's a prohibition on sales of handguns. Does that sound familiar? Oh, yes, it is a gun ban. They are banning all modern handguns that were not already on the roster. Because it is a gun ban case, do we have any Supreme Court precedent in American life that we on this channel might be able to point to say, how does one as a judge or as an attorney deal with a gun ban law? Oh yeah, that's called Heller versus the District of Columbia, as well as McDonald versus Chicago, as well as Caetano versus Massachusetts. In all those cases, when a handgun, or in the case of Caetano, a stun gun, was banned, Guess what? The proper question, based on the Supreme Court's precedent, is are the banned arms, are the banned guns, in this case, are the guns banned by California? And they are gun bans because you're not allowed to have them or buy them if they're not on the roster. Is that gun ban prevent Californians from being able to possess guns, handguns, that are in common use in America, the whole country, in common use by Americans for lawful purposes? And it is 100% the case that all of the handguns that are being banned from sale in California are in common use by Americans for lawful purposes all across this great country. And it doesn't matter about the state of California because the Second Amendment is a national law that applies as equally to New York City, as equally to Monterey, California, as equally to Alaska, as equally to a town in Texas. It's the Second Amendment that applies to all Americans all across America. This was a gun ban case. Because it's a gun ban case, all this court had to do was apply Heller, which is still good law, undeniably good law, because Bruin cites to Heller favorably in 2022. And Heller says that, again, if you're dealing with a ban on a gun, is the gun, or is that type of gun, in this case handguns, over the age of basically the classic firearms that are being banned by California for all are handguns that have been made after 2007 or handguns that have been made after 2013. It doesn't matter. Either is a class of firearms that are in common use. So has California banned all handguns that were manufactured and produced after 2007/2013, which is critical dates for the handgun roster, not material for our discussion here? The answer is, of course they have. This is a gun ban case. Because it's a gun ban case, all that needed to happen was ask the question, are the guns being banned by California in common use by Americans for lawful purposes? The answer is undeniably yes. It's game over. Game over. Now, we've talked about this before, and I actually flagged this potential mistake a few months ago on the channel. I said, you've got to be very careful here when you're litigating these cases, because it's very easy to forget that Heller remains good law, and if you're dealing with an arms ban case, you apply Heller. If you're applying with anything else, like a regulation on carriage, a regulation on licensing, a regulation on 18 to 20-year-olds being able to buy guns, things like that, maybe on the so-called ghost gun fight, which is self-made firearms. If you're dealing with issues like that, regulation of those things, then you might apply the Bruin test of plain text and then historical analogs bearing the burden of the government. Now, keep in mind, people have asked me, I want to be very clear about this. Heller and Bruin are entirely consistent with each other. And I want you to understand how they work together. It's extremely important that you understand this. It's very easy to understand once I explain it. Heller applied the Bruin text, history, and tradition test. In Heller, you see, we today talk about Bruin's methodology of text, history, and tradition, meaning you look at the text, and then you look to see if there's any historical laws that restrict the text, and then you decide the proper legal standard, and then you apply it to the modern-day gun control law. You see, the Bruin text, history, and tradition standard is actually should not really be called the Bruin text, history, and tradition standard. It actually should be called the Heller text, history, and tradition standard, because what Heller did was the exact same methodology of Bruin. Heller applied the text, the history, and the tradition dealing with American gun bans, and it concluded that the only time of weapons that can possibly be banned are if those weapons are dangerous and unusual. But because all the weapons we're talking about, at least today, AR-15s, handguns in California that are not on the roster, magazines that hold more than 10 rounds, because these arms are obviously in common use in America today, they can't be banned, because it's impossible for them that is in common use in America to be deemed dangerous and unusual, which is what the government has the burden to prove, that an arm is dangerous and unusual before it can be banned. And they can't do it if something is in common use, obviously. So again, we can talk more about these legal things in future videos, but all I want to say is this. This case, and I congratulate the people involved in this case completely, the case of Boland versus Bonta, and also I think Judge Carney got it right at the end of the day. But going forward, there's nothing wrong with the analysis he did, but it was totally unnecessary, and it's not the right methodology. The methodology has already been done dealing with an arms ban case. This was an arms ban case. Heller needed to be applied. That's the in common use test. Because the guns that have been banned by the state of California, and they have been banned because if they're not on the roster, they can't be sold in the state of California, which is effectively a gun ban, you simply ask, are the guns that are not on the roster in common use in America all across the country? They clearly are. There's no dispute about that. I mean, the Heller case specifically said that handguns as a class are protected arms. So it's like game over. So this should be an extremely easy case to knock out this handgun roster. And in fairness, I have not looked at the handgun roster issue in California because frankly, you know, there's a lot going on in California. I try to hit the highlights. And since the handgun roster is so unique to that state, I frankly have not focused on it until I read this opinion. But anyway, neither here nor there. The good news is, good outcome. It's the correct outcome. This is clearly unconstitutional, but there's an easier, simpler way to get to the same outcome in addition to what Judge Carney did, which is to kind of do the analysis that the Supreme Court would do in the Heller case. But again, the conclusion, the product of Heller is already in existence in the in common use test. That's all that needs to be applied here as I see it. But either way, I just want the Second Amendment to win, and I think it's easy to win with the in common use test in the California handgun roster case. Again, I welcome comments and criticisms if you guys think I'm missing something here because I'm new to the California handgun roster fight, but that's how I see it, and hopefully this is helpful to some of you guys out there on the West Coast. Okay, folks, if you haven't subscribed to the Four Boxes Diner, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.